Missouri Medical Marijuana Draft Rules released. We're looking at the Medical Marijuana Facilities Generally Draft Rule. This is the second video in our reviews of the draft rules proposed by DHSS for medical marijuana in Missouri. The first, on qualified patient and primary caregivers, was posted a couple weeks back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This rule details how the department will accept the applications for licensing and certification of cultivation, infused products, manufacturing, dispensary, testing, and transportation facilities on August 3rd, 2019. The rule in Section 1, Paragraph A, states it will accept applications for facility licenses or certifications electronically through a web-based system. Section 1, Paragraph B covers the impending introduction of application periods. Apparently, the department is going to limit applications to specific periods. Fees will continue to be non-refundable, and after the first application period, fees submitted outside of an application period will not be accepted. The big thing to consider is Section B3, which reads, if licenses or certifications are available after a time period for accepting applications has passed, the department will determine when to publish on its website a new time period during which it will accept applications, and will publish that new time period on its website at least 6 months prior to the beginning of that time. What that means is potential licensees cannot wait for the initial frenzy to abide and then apply. When the department closes the initial period, there will be no new applications accepted until the next period, which is going to be at least 6 months away. Now, before I go on with the rest of this draft rule, I have to say, this is a terrible way to run this program. Liquor licenses don't work this way. I think this is going to create a situation where big money and entrenched interests rule. The 6-month delays pretty much promise that smaller enterprises are going to wind up being locked out in practice. The concept of only accepting applications in periods seems to run counter to the intent of the Constitution, which clearly states that the goal is to make medical marijuana available and affordable. When applications are submitted, the applicant will be notified of any missing information in the application. The applicant will then have 7 days to provide that missing information. Section 1C is where this gets interesting. The issuances of a facility license or certification does not authorize the facility to actually begin operations. A facility will be granted final approval to operate only after passing a commencement inspection. So, for the sake of discussion, you pay 6 large for a dispensary application fee. Anywhere from 25 to 50 large in fees to prepare the application. Then you're awarded your license. After you're awarded the license, you get to spend anywhere from $1 to $5 million to build out the facility, hire staff, commence training. Then you will have a final inspection. Failure of that final inspection means loss of your license. Section 1D states that licenses and certifications for the facilities may be suspended, denied, or revoked. It has criteria. First, if a facility provides false or misleading information in its application may be denied, or if the information is later discovered to have been false or misleading, its license or certification may be revoked. Plans, assurances, and projections offered in answers to 19 CSR 30-95.020, paragraph 4, evaluation criteria questions, may be considered false or misleading if, upon application for license renewal, the department determines the facility has not made a reasonable effort to implement or follow through on those plans, assurances, or projections. If a facility violates any provision in this chapter or fails to comply with a corrective action plan, its license or certification may be suspended or revoked. 3. If an applicant fails to provide a complete application within 7 days of being notified that an application is incomplete, the license or certification for which the applicant is applying will be denied. They added this in several different places, so they must actually be serious about that. 4. If a facility is granted a license or certification but has not passed a commencement inspection within 1 year of the department issuing the license or certification, the license or certification may be revoked. Now, you better make sure that you have your blueprints, builders laid on before you apply. These construction projects are going to be time consuming, and they're going to have to be pushed for speed. 5. If a facility fails to comply with a department order to immediately suspend all or part of its operations, the license or certification shall be revoked. The rule also contains requirements for renewal, and now what the application must contain. Section 2, Application Requirements. Facilities must obtain a license or certification to cultivate, manufacture, dispense, test, and transport medical marijuana in Missouri. All applications for facility licenses or certifications and for renewals of licenses or certifications shall include at least the following information in a department-provided format: name and address of the applicant, the legal name of the facility, and a certificate of good standing from the Missouri Secretary of State. Names, addresses, and social security numbers of each known owner, principal officer, and manager. The percentage of ownership shares that each facility owner will possess, and a copy of the facility's operating agreement. Each owner's residence address, and in the case of a majority owner, a statement that the owner has primarily resided in Missouri for at least 1 year, with the intention of permanently or indefinitely residing in Missouri, as well as proof of current Missouri residency, which shall be shown by 1. A valid Missouri driver's license number or Missouri identification card. 2. A copy of a current Missouri motor vehicle registration and a recent Missouri utility bill. Or 3. If none of these proofs are available, some other evidence of primary residence in Missouri, which shall be approved or denied at the discretion of the director of the medical marijuana program as sufficient proof of residency. Side note, I believe this is not constitutional. I will in the very near future do a video on the Dormant Commerce Clause that will explain why that's not constitutional. F. For any owner, principal officer, or manager who was previously associated with an entity licensed in a jurisdiction outside of the state of Missouri to cultivate, manufacture, test, or distribute marijuana, you need a copy of the license or other documentation verifying licensure in that state. If the license was ever denied, suspended, revoked, or otherwise sanctioned, a copy of the documentation verifying that action, and a written explanation for such action. For any owner, principal officer, or manager who was previously or currently is associated with an entity licensed or certified or applying for licensure or certification in Missouri to cultivate, manufacture, test, or dispense marijuana, you need a list of those facilities designating which of the owners, principal officers, or managers are associated with them. 2, you need a list of facilities over which any owner has or will have substantially common control, ownership, or management. And then 3, if the license was ever denied, suspended, revoked, or otherwise sanctioned, with a copy of the relevant documentation verifying such action and a written explanation for the action. H, you have to have a proposed address of the facility and 1, a map of the surrounding area that shows compliance with the facility location requirements of Section 4B of this rule, or 2, documentation showing a local government requirement that's different from the requirement in Section 4B of this rule, and a map of the surrounding area that shows compliance with the facility location requirements of the local government, and 3, an attestation that the proposed address of the facility complies with the facility location requirements of Section 4B. That's just absolutely ridiculous. I, description, schematics, or blueprints for the facility. If the city, town, or county in which the facility will be located has enacted zoning restrictions applicable to the facility, the text of those restrictions and a description of how the facility plans to comply with those restrictions has to be included. K, evidence that the facility complies with all the requirements for transportation certification in 19 CSR 30-95.100. L, for all owners, principal officers, and managers identified in the application, the results of a state and federal fingerprint-based criminal background check conducted by the Missouri State Highway Patrol within the previous 6 months. And a statement that the individual has no criminal record in any state not covered by this background check. Or if the individual has a criminal record in any state not covered by the Highway Patrol's background check, the results of a fingerprint-based background check from the other state or states conducted within the previous 6 months. All facility evaluation information required by 19 CSR 30-95.020 paragraph 4, and all applicable fees or proof that the applicable fees have been already paid. This is generally what the application is going to have, all of them. There are going to be some changes to this, and there will also be a lot of additional specific requirements for the type of facility. Now, continuing on with the rule, Section 3, facility ownership and employment. An entity can own no more than 3 cultivation or 3 manufacturing, and no more than 5 dispensaries. Yes, you can own up to 8 facilities. You cannot own a testing facility and either a cultivation, manufacturing, or dispensary facility. All employees must have an agent ID card. Applications for the agent ID cards will begin being accepted February 15th, 2020 through an electronic system. They will require an extensive background check and be valid for 3 years. The cost is set at $150. Facility operation, policies, and procedures. There is a lot in the policies and procedures that really only applies if you are considering opening a facility. One point that seems to come up is excess marijuana must be turned into a dispensary. I would expect that dispensaries are going to charge to accept it, as they have to account for it and dispose of it. Reclaimed marijuana will not be eligible for resale. Facility inspections. Submission of an application constitutes consent to inspection. Inspectors must be given immediate access to the facility without delay. Violations can result in remedial actions, and requirements to fix issues in violations have to be done within 15 days for the next inspection, or if they fail, 30 days for a second inspection, third inspection. And licenses may be suspended or revoked as a result of that failure. There's some good stuff in the draft rule, and there's some very concerning things. It is a draft rule. You can submit suggestions, and you can go through the DHSS website in order to do so. We're making progress, but the rule itself shows that DHSS is really being brought through this quite grudgingly. You can't open without employees that are trained, staff that has a facility ID card. That's going to cost $150, and they won't begin accepting the application until February 15th of 2020, which means that the absolute earliest that you're going to have medical marijuana on the street is going to be summer of 2020. Once the facility employees are able to work and they approve to begin cultivation, that's probably not going to happen until March. Say March at the earliest, possibly April. You're going to have growth time, you're going to have testing, distribution. It's going to go out to the dispensaries. Dispensaries are going through the same process. They're not going to be open until early summer of 2020 either. You're talking summer, maybe even fall. These are important issues. Please watch our videos,